additional 1 or 2 minutes to allow other participants to join us on this conversation. So we're going to start by 14:05. That's by 2:05 p.m. Thank you. All right. Good afternoon once again, everyone, and thank you for taking our time to join us on another edition of ELAN webinar series. ELAN, like I said earlier, is the Employment and Labor Lawyers Association of Nigeria. ELAN is the premier network of legal practitioners that specialize in employment and labor law. ELAN was established in 2015. The aim of ELAN is to be the leading resource for expert guidance on workplace-related legal matters in Nigeria. Today on this webinar, we are going to be discussing an overview of the Nigerian labor law and regulations. We're going to consider the provisions of the Nigerian Labour Act. We'll look at various sector-specific regulations. We'll look at international labor codes and treaties that relate to labor and employment. We'll look at the National Industrial Court, the applicable rules of the court, the jurisprudence, and the stance of the National Industrial Court, as the NIC, on some of the labor issues. We'll look at the new order of work, and to take us through this conversation this afternoon, I have our amiable facilitator, in the person of Mr. Nonso Azzi, sorry. Thank you for taking out time to join us on this conversation this afternoon. Before I yield the floor to Mr. Nonso, I'm going to take a couple of seconds to read his profile. I'd use the word seconds advisedly because he has a very long feathers on his cap. And then just to save us some time, I'll just briefly summarize his profile before I yield the floor to him. Mr. Nonso, a seasoned lawyer with expertise in commercial litigation, maritime, employment, family law, arbitration, mediation, and structured legal advisory services. He has a rich professional background. He had worked at leading law firms, including Bawa and Nigadalo, Denton Akers Law, and Foundation Chambers. He is currently the principal counsel at Hazy and Hazy Legal Practitioners and a sought-after resource person and consultant in core areas of legal and allied matters. Mr. Azzi is the convener of the Nonso Azzi Law Practice Development Seminar and the Nonso Azzi Young Lawyers Career Development Seminar. Both are judged as excellent career development platform. He's a member of several national and international organizations. He is executive member of the Nigerian Maritime Law Association. He's a member of the Nigerian Admiralty Law and Procedure Reform Committee and a committee lead at the Employment and Labor Law Association of Nigeria, ILAN. He's been recognized as Next Generation Lawyer in 2017 by Legal 500 in shipping and transport for India, Middle East, and Africa. He's been acknowledged for handling landmark cases in commercial, maritime, and employment law, and he has earned commendation from judges for outstanding courtroom advocacy and commitment to sound law practice anchored on diligence and trust. Mr. Azzi obtained his LLB from the prestigious University of Nigeria. He holds an LLM from the Great University of Lagos, and he has a certificate in Maritime Dispute Resolution Arbitration from Lloyd's Maritime Academy, United Kingdom. Mr. Nonso is a notary public and a certified mediator of the Lagos State Multi-Door Courthouse. I believe that you will agree with me, having read Mr. Nonso's profile, that we have a round peg in a round hole, and is able to do justice to the outline of subtopics we are going to be discussing this afternoon. Thank you, Mr. Nonso, once again for joining us on this webinar, and then I yield the floor to you.
Thank you, Akinola. Can you hear me? Hello, can you hear me?
Yes, we can.
We can.
Okay, thank you. I hope my video is showing. Good afternoon, ladies and gentlemen. My name is Nonso Azzi. I first of all want to thank Elan, which I'm a member, for putting up this webinar / training, on overview of Nigerian labor law and regulations. There is a lot to talk about. The slide has been provided as a guide. There's a detailed paper which will be shared, to all those who registered by mail for this webinar. So without much ado, we all know that labor and employment law jurisprudence has over time become a topical issue in Nigeria. With the advent of the National Industrial Court, those who did not take employment and labor law seriously, were jolted up to know that, Nigeria deemed it fit to set up a court that is on the same level with High Court to focus principally on employment and labor law. So that will tell anybody that, the position that labor and employment law occupies, in Nigeria. And a lot of lawyers have, in recent time, found a new lease of life in handling employment and labor law cases. So part of what Elan tries to do is to continually engage stakeholders and teach and conduct webinars for us to begin to continue to discuss some of these issues that revolve around emerging trends in labor and employment law. So basically, we'll start by saying, maybe a definition of what labor and employment really is. I mean, the word labor in its ordinary meaning, ordinary and legal sense, could refer to the physical and mental efforts expended by human beings in the production of goods or the provision of services in exchange for, remuneration. So accordingly, in the most fundamental sense, the human contribution to economic activity, distinct from the capital on the one hand and land on the other hand. So that human element in the factors of production. So in the context of law and industrial relations, labor denotes not merely the act of working, but the entire body of relationship rights, obligation, and interests that arise from the fact of a person placing their physical or mental capacity at the disposal of another for economic purposes. So there has to be a reward, So it's important to draw a distinction between labor law and employment law, in that while labor law relates to collective employment relations, employment law deals more with individual rights within the employment context. So when you talk about collective agreement, for labor union and things that affect those who work, whether they call them laborer or you call them employees, in general, you can be talking about labor. But when it comes to Mr. Azi, if I work for company A, the contract of employment provision as to redundancy in handbook and all that can be classified as employment law. So what is the object? We have to go a bit academic, and that will take me to what Honorable Justice B.B. Kanye, PhD, who is the president of National Industrial Court, said. He drew inspiration from the scholarship of Professor Manfred Weiss and Hugo Sinzheimer, one of the founders of German labor law. They stated that the object of labor or labor law is as follows. Number one, that labor should never be treated as a commodity. A view reinforced by the International Labour Organization Philadelphia Declaration and Poplio's Rerum Novarum. I mean, what are they trying to say? That labor should never be treated as a commodity. Then inherently creates a relationship of personal dependency, necessitating protective regulation. So you can't just leave people to go and work in the olden days where you can do anything to whoever is your slave or whoever is working for you. So the current trend is that employment inherently creates a relationship of personal dependency, necessitating protective regulation. Number three, human dignity must be preserved within the workplace. Number four, labor law should address all phases of the working life, including job seekers and retirees, not just current employees. I was discussing with one of our trustees today, Minister Kolade, on someone who had been offered a job by a company. He resigned from where he was working, and the new company that employed him, that had given him more like have accepted him, that was an offer and acceptance, and they have told him you're going to resume. They made a votive fashion and said they're not going to employ him again. And I mean, the issue is that can he go to court to reasonable expectation and all that? So labor law encompasses all phases of working life, even protects job seekers, how job seekers are treated and their rights and privileges. Then finally, employees should have a choice, a voice in workplace decision making, affirming the importance of the democracy within employment structures. So a notable writer on labor and employment law, Mr. Bimbo Atilola, in his book, Labor and Employment Law in Nigeria, The Practitioner's Guide, situates the concept of labor within a broader social and economic framework. He observed that labor is the most essential factor of production, and that the regulation of the condition under which it is supplied and utilized is one of the primary functions of the state. This is why labor law exists as a distinct legal discipline, because without legal regulation, the inherent inequality of bargaining power between the individual worker and the employer will leave the worker vulnerable to exploitation. You know, there's this argument that, oh, National Industrial Court is tilted towards the employee as against the employer. And what I tell people is that there is no deliberate effort to jeopardize the interest of employers. What actually happens is that if you look at the historical antecedents, you will agree with me that over time, from time immemorial, employers of labor had better bargaining power, and it's still the reality today. So the idea is that the person who is at the receiving end should have some form of protection. And it takes nothing away from the fact that employers also have their own rights and privileges. If you go to NIC or if you read through NIC judgment, people think that NIC is there just to dish out judgment and damages to employees. If you go through NIC judgment, you see a lot of cases that were thrown out or lacking in merit, and where NIC stood their ground to actually enforce the rights of employers. So we look at the Constitution, we look at Section 17.3, with the directive principles, but they are still part of the Constitution, which direct the state to ensure that all citizens have the opportunity for securing adequate means of livelihood, as well as adequate opportunity to secure a suitable employment, and that conditions of work are just and humane. We look at Section 14.2 sub B, which further declares that the security and welfare of the people shall be the primary purpose of government. In the international context, the International Labour Organization, of which Nigeria was a founding member, defines labor in terms of the working population whose rights and working conditions it exists to protect and promote. So we look at ILO foundational instruments, including the Declaration of Philadelphia 1944, which affirmed that labor is not a commodity, a principle that has profoundly influenced the development of labor law worldwide, including Nigeria. So we talk about employment, which we have said is that it is the relationship that arises when one person, the employer, engages another person, the employee or worker, to perform work or render services under the employer's direction and control, ordinarily in exchange for remuneration. So it is the legal framework through which labor is organized, regulated, and protected. So you look at Section 91 of the Labor Act, which defines a contract of employment as any agreement, whether oral or written, express or implied, whereby one person agrees to employ another as a worker, and that other person agrees to serve the employer as a worker. So what is fundamental is that an employment agreement, in parentheses, need not be in writing. It could be oral. What is important is that whether it is express or implied, if somebody comes to your house to do a particular work every day, and a pattern is formed, and you pay the person, whether in cash or in kind, and the person continues to come for 3 years and all that, one can actually state that an employment contract has been, effected, even though it's not written. So this definition captures the bilateral character of employment. It is a consensual relationship founded on agreement, and it gives rise to mutual rights and obligations between the parties. So there's this international book, Barrow and Leon in Modern Employment Law. They observe that employment as a legal relationship is distinguishable from other relationships involving the performance of work by reference to the element of subordination. The fact that the employee works under the direction and control of the employer, as distinct from an independent contractor who retains autonomy over the manner in which the work is performed. This distinction between a contract of service, when we talk about contract of service, we're referring to employment, and a contract for services, we're referring to independent contractor, somebody who has been hired and retains some control over the work he does. It's a key element in labor law, as it determines whether a person is entitled to the full range of statutory protection available to employees or not. Nigerian law recognizes 3 categories of person in the context of employment. So there is this controversial issue of workers. Who is a worker under the Labour Act? And the workers are defined under Section 91 of the Labour Act as persons employed under a contract of service to perform manual labor or clerical work. This category attracts the full range of statutory protection under the Act. So then employees are called non-workers or are persons who perform administrative, executive, technical, or professional functions. Their employment is governed primarily by their individual contract and the common law, as the Labour Act arguably does not apply to them. So that argument is not the essence of this. It's going to be a webinar on its own, whether the Labour Act covers those who are defined as non-workers or so-called employees, whether it's just for the clerical and the laborers. Independent contractors are engaged under a contract for services and are generally excluded from statutory employment protection. You know, when somebody is independently working as a contractor, they are not covered under statutory protections such as pensions and workmen compensation and all that, depending on the circumstances. So a notable writer and one of our trustees, Jeremy Akolade, in his book, The Employment Law Handbook, I encourage everybody to go and look for that book. He states that this classification of categories of employment is not merely academic. It determines whether a person is entitled to notice, severance pay, pension contribution, compensation under the Employees Compensation Act, and the right to sue at the NICN. So the bottom line is that if you are an employee or if you're an employer, you need to understand the category of the employer, of the employee that is working with you, whether the person is an independent contractor or the person is an employer, strictly so-called. So employment as a concept also encompasses the public dimension, the relationship between the state as employer and its servants. And that is where we come to, some of you must have heard, if you read NICN judgment or other judgment before, pre-NICN, you'll see things like statutory flavor. It's a very common expression, which means that the terms and conditions of such employment are prescribed by statute and cannot be altered or terminated except in strict compliance with the applicable statutory procedure. So this distinguishes fundamentally from private sector employment, which is primarily contractual in character. If you're working for government, that is, the government does not issue you a particular contract which guides they can state your level and all that. But whenever it comes to, what your rights and privileges are, it is typically as established by the statutes. For instance, if you work for University of Lagos, which is a federal university, the University of Lagos Act has some provisions relating to what can happen. And then it is interesting to note that generally, reinstatement is not easy for private workers. If you're working for Shell and you have been unlawfully terminated, and if one of your prayers is a prayer to reinstate you to come back to Shell, I haven't seen a case in the recent past where the court agreed to that. The court can give you damages for the wrongful termination. The court can give you sorry, I was distracted by a message that came in. Nakanda will do that. The court can give you damages, sufficient or not, for the loss you have suffered, but not to bring you back to MTN to come and look at the boss who terminated you unjustly. But if it's Unilag, you're a lecturer, you see some cases, University of Lagos, other federal agencies, because it's federal government, if it is established that you were wrongfully terminated, your right to come back to Unilag is protected as against private workers. So the Supreme Court in SS Company Limited versus Afropac Nigeria Limited, the 2008 case, identified several criteria for determining whether a relationship of employment exists. And that includes the degree of control exercised by the engaging party over the manner of performance of the work, the degree of integration of the person into the organization, who bears the financial risk, the method of remuneration. So these criteria guide courts in resolving disputes about the true nature of a working relationship. So we look at labor law and employment law. Labor and employment law as regulatory disciplines. So from the foregoing, it follows that labor law and employment law are the bodies of law that regulate labor and employment respectively. Labor law in the broader sense encompasses both individual employment law, governing the bilateral relationship between the employer and the employee, and collective labor law, governing the tripartite relationship between employers, trade unions, and the state, including collective bargaining, industrial action, and dispute resolution mechanism. Employment law, in a narrower sense, focuses specifically on the individual employment relationship, the contract of employment, terms and conditions of service, discipline, and termination. So both terms are largely used interchangeably. And we look at Section 254C sub 1 of the Constitution of the Federal Republic of Nigeria as amended, which defines the subject matter jurisdiction of the National Industrial Court, and by extension, the substantive scope of labor and employment law in Nigeria to include, if you look at Section 254C of the Constitution, C1 of the Constitution, you will see that what labor law and employment encompasses is labor, employment, trade unions, industrial relations, conditions of service, health, safety, and welfare of labor, and all matters incidental or connected therewith. So let's just quickly run through statutory frameworks for labor and employment law. Of course, we have the Constitution, which is the ground norm from which all employment-related legislation derives its validity. Then you look at Chapter 2, Fundamental Objective. I've mentioned Section 17, Sub 3. Chapter IV, Fundamental Rights. The following provisions have direct application and implication in labor and employment law. You all agree with me that if you look at our laws, of matters that borders on fundamental human rights, provided that it flows from employment relationship. So we have Section 34, right to dignity, which prohibits forced labor and degrading treatment. Section 36, Section 40, Section 42, freedom from discrimination, freedom of association, fair hearing. All this dovetails because when you're working in a company and you have a query, and if you're not given fair hearing, it's a basis for you to challenge such in court. So Section 34, 36, 40, 42, they're all relevant to the subject of discussion. Then the third alteration that took place in 2010, which created National Industrial Court and which empowered the court to adopt international best practices. That is one of the highlights of the third alteration, apart from creating the National Industrial Court and imbuing it with that jurisdiction that covers labor and employment issues and connected matters. The interesting point is that international best practice in labor and employment and industrial relationship matters. So, but we will discuss that. A writer had described this as the most significant development in Nigerian labor law jurisprudence since independence, because Section 254C sub 2 further empowers the NICN to deal with matters relating to the application of any international convention, treaty, or protocol that Nigeria has ratified relating to labor, employment, and workplace matters. So the question is, the operative word is international treaties and conventions that Nigeria has ratified, not domesticated. And what comes to our mind is what we were taught. Section 12, the almighty Section 12 in constitutional law. Anything that has not been domesticated is null and void, blah, 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 blah. It cannot apply in Nigeria. It has been domesticated. And the question is that why must it be domesticated? So a leeway can be found depending on which side of the argument you belong to or which side of the divide you belong to. If Section 12 has said that no international instrument or treaty or convention will be applicable to Nigeria without domestication, Section 12, fine. We now run to section 254. It tells you, notwithstanding any other provision, that I have given you the power in the determination of Mr. Kolade's right, if he has approached the National Industrial Court, or Mr. Aziz's right, or Mr. Umar's right, that you can adopt international best practices. That conundrum is still there. People still believe that, oh, I call them those who belong to the old school, that it must be domesticated before it can apply. But we're going to come to that. We're going to come to that. So then we look at the Labour Act. It is important to note that the Labour Act is the principal statute governing individual employment relations in Nigeria. It covers contracts of employment and the statutory requirement of written particulars, wages, annual leave, sick, maternity leave, termination by notice and summary dismissal, and other things. So the limitation of the Labour Act is the restriction of its application to manual and clerical workers, meaning that a large and significant segment of the organized Nigerian workforce falls outside its coverage. The last time I checked, I think legislative moves have been made to expand the scope of the Labour Act to cover all categories of employees. Then we look at the Factories Act. We can look into that in detail. Factories Act makes provision that regulates health, safety, welfare in factories and industrial establishment, registration of factories, sanitation, ventilation, everything that makes your workplace. For instance, you go to some companies, you go to some offices, they don't have fire extinguisher. Let me start from that. Keeping your workplace safe. That is what that one stresses. So there are cases, Ola Suleiman and Hong Zing Steel Company Limited. The court stressed that employers are under both statutory duties under the Factories Act and common law obligation to maintain safe systems and equipment, and that these obligations are cumulative, not alternative. You can't say I have fire extinguisher, but I don't have, proper electrical wirings, and somebody is exposed and the person dies electrocuted. The common law duty of care requires an employer to provide a safe workplace, competent fellow workers. It's interesting. You can go and employ half-baked employees who pose a risk to other employees. These are issues that you can actually sue for. Adequate supervision and suitable equipment was affirmed in Western Nigerian Trading Company Limited versus Busari Ajao 1965, where the court held that the duty extends not merely to providing safety equipment, but to ensuring that employees actually use it. I used to work at Maersk as head of legal. If you go to the container yard where the containers are stacked without wearing a helmet or boots, safety boots, you just go from there. There is no problem. You just consider yourself sacked or terminated, because safety, as they say, is their license to operate. You just go there, and once they cite you that you are walking around the terminal stacking area without safety helmet, you're going from there. And when you want to go to the stacking area, there are marked paths that you must take. You can't just be walking aimlessly, So there is a duty on the employer to ensure that the safety and welfare apparatus that you have in place at your workplace are being used by your worker. So we look at the Pension Reform Act 2014. The first one was in 2004, and then 2014, which replaced the old one. So what is interesting in this Pension Reform Act is that the 2014 Act repealed and replaced the Pension Reform Act 2004 and established a mandatory contribution scheme for all employees in the public service of the Federation and the Federal Capital Territory, and for employees of private sector organizations with 15 or more employees. So the important thing to note is that it replaced the old defined benefit scheme with a defined contribution scheme, under which both employer and employee make contribution into a retirement savings account. I think most of us know this. So the shift from a defined benefit to a defined contribution model was a fundamental structural reform designed to address the chronic underfunding and mismanagement that characterize the prior system. I mean, the pension reform system can be likened to what they have in US. I think they call it the 401k, which works very well. So we look at ILO conventions. I mean, if you go online and click ILO convention, you see a lot of them. Just like maritime law, in labor law, somehow it's largely international in that there are conventions that the Committee of Nations come together to frame, and then everybody will begin to localize it based on its local peculiarities, but largely it's an adaptation of the convention. So there are a lot. Convention 87, freedom of association and protection of the right, a lot of them. But Nigeria has actually ratified several core ILO conventions, but there is one important convention that Nigeria has not ratified, and that is ILO Convention number 158 on termination of employment. It was made in 1982. But the NICN has applied its principles, particularly Article 4, which requires a valid reason for termination connected with the employee's capacity, conduct, or operational requirements. If you read ILO Convention, it's a very interesting convention. I will encourage everybody to go look for it. ILO Convention 158 on termination of employment 1982 states in Article 4 that you cannot relieve anybody of his or her employment except if the reason is connected with the employee's capacity, which means, can he do his work? Has he or she been failing in doing his work? What performance improvement plan did you put in place to make the person better, and the person is not coping, and finally he's terminated? That relates to employee's capacity to do the work for which is being paid for. Then conduct, gross irresponsibility or gross misconduct, or operational requirements. Operational requirements cover the issue of redundancy. Oh, Mr. Azi used to be the terminal truck driver, but somehow the terminal had been mechanized in such a way that that container that he used to take from one place to another can now be done by a machine. You cannot slow the hands of technology. So you can tell Mr. Azi, you are now redundant because there is no job for you, or that too many people are doing one particular job that we have to shed some weight, or we're not able to maintain cash flow, or what is it called again? Our payroll, something like that. So that is what the convention said. But the conundrum has been that because we are coming from the common law rules, I was talking with a senior lawyer the other day. He said, no. So God forbid that the day will come when an employer will lose the right to hire and fire. But that's in the past, because the plethora of authorities at National Industrial Court tilts towards the principle as contained in ILO Convention 158, which says that you must not only give reason, but you must give a valid reason, which must dovetail into employees' capacity, conduct, or operational requirements. So they still argue, oh, that ILO Convention has not been domesticated. We have not even ratified it, not talk of domestication. So it becomes a fight between Section 12 and Section 254C, depending on how you interpret it. So we hope that the Supreme Court will one day, give an end to these imbroglio. So when you look at Court of Appeal, you see that Court of Appeal has also shifted somehow, I think in cases like Keystone Bank and Afolabi, if I'm not mistaken, to begin to adopt some of these principles that are being enunciated, are being, supported by the National Industrial Court. So this application of unratified convention has been the subject of judicial debate, with some NICN decision holding that unratified convention must first be specifically raised and proved by the parties before the court can apply them, which is fair enough. So for anybody who intends to file anything at National Industrial Court, most judges will expect you to actually plead them. In your pleading, you should state that I am relying on ILO Convention 158. I was sacked without a reason, and I'm relying on this, and I'm pleading it blindly. You have to prove it specifically and show the court, this is what I'm relying on. Then the court will now fall back on 245C and uphold that right. So the Court of Appeal in Keystone Bank and Afolabi also affirmed that the common law right of, okay, no, it's the other way. Yeah, sorry, I used that case earlier, but in that case, what the court said is that the common law right of an employer to terminate without reason remains valid, provided the terms of the contract are complied with. That's Keystone Bank versus Afolabi. It's a 2017 case. But there are other cases in Court of Appeal where the Court of Appeal agreed with NICN judgment that, oh no, you have to give a valid reason. So it is not settled. We'll still go to mention a Supreme Court case, both of them 2024 Supreme Court. One favored adoption of international best practice. The other one said, no, you must go back to the common law era where you can hire and fire, but provided you follow the provisions of the contract of employment. So the significance of ILO Convention for Nigerian Labor Law lies not only in the directly ratified instrument, but in the power conferred by Section 254C sub 1F and 2 of the Constitution and Section 7 sub 6 of the National Industrial Court Act. Yes, 254C1F sub F and 2 is in pari material with Section 676 of the National Industrial Court Act. Yes, because these sections or this provision give the NICN the power to use them as a body of international best practice in resolving labor disputes before it. So we look at the National Industrial Court Act 2006. We can read that and digest it. The Employees Compensation Act of 2010. It replaced the Workmen's Compensation Act and established a comprehensive no-fault compensation scheme for employees who suffer work-related injuries, occupational disease, or death in the course of their employment. So under the Employees Compensation Act 2010, you don't need to state the fault. Oh, it was his fault, or he was faultless. So the no-fault character of the scheme is significant. An employee does not need to prove negligence or fault on the part of the employer to qualify for compensation. All that must be shown is that the injury, disease, or death arose out of and in the course of the employment. So if you are working in an environment during COVID-19 and you had COVID and you should be compensated. Some of us lost our sense of smell during COVID. We didn't catch COVID, but I just woke up one day and because we were going to work then and realized that I couldn't smell anything for like 2-3 days. And I wasn't quarantined, but I just thought that I got better, took the shot and all that. So the Employees Compensation Act, it's something that you have to look out for. You know, clients can come to meet you to activate their right under there. So the ECA applies to all employees in both public and private sectors. It established the National Social Insurance Trust Fund. Some of you must have been hearing about NSITF. Yeah, it was established under this act, you know, for managing employees' compensation fund, into which mandatory employer contributions are remitted. So employers are required to report work-related injuries and occupational diseases to the NSITF board within 7 days of occurrence and immediately in the case of death. You know, there are cases there when I share the detailed work, we can look there. Then we have the civil service regulations, you know, public service rules. We have the Armed Forces Act, you know, which states, because they have their own, the members of armed forces are not subject to some of these civilian rules. They have their own special rules, and which is governed exclusively by military regulation and the provisions of the Armed Forces Act, which establishes separate military courts and disciplinary procedures. So you look at the Police Act, you know, similar to Armed Forces Act, then other relevant legislations. Then we look at the HIV and AIDS Anti-Discrimination Act 2014. It prohibits all forms of employment discrimination based on an employee's real or perceived HIV status. Prohibits compulsory workplace HIV testing without employees' consent. Yes, if they take your blood, you want to join Seplat, or you want to join MTN, or you want to join another company, and they take your blood and they didn't tell you, and they go and do HIV, you have a right, to challenge that. And I mean, it also mandates employers with more than 5 employees to maintain a written workplace HIV/AIDS policy. You have to embed these policies to know what guides the company. We have the discrimination against persons with disabilities. Yes, when you're employing, if somebody is competent, regardless of his disability, such person should be employed. I have the Nigerian Data Protection Act 2023. Before 2023, we had the NDPR when it was still a regulation, but with the advent of NDPA, it is now codified. So in the employment context, employers are data controllers in respect of all personal data they collect, process, or store relating to employees, job applicants, and former employees. So you have a right. I mean, as you go about searching for job, as you move jobs, you provide your home address, you provide some details that ordinarily you wouldn't provide to a regular person. So as a data controller, your employer has that burden to make sure that that data is actually used for legal purposes or the exception that are permissible. So when it comes to processing, storing of this data, health and medical records, yes, you do a test. The company will say, oh, let's do tests. Annual medical checkup, the company keeps the record, the company keeps the result of whether you have this or you don't have that. Under NDPA, your rights are preserved. So there are cases, and we'll discuss that we have to flip all so we can stay within time. Common legal and regulatory requirements in employment and labor relations. So we talk about requirements of an employment contract, nature and formation. A contract of employment is the legal foundation of the employment relationship. It's unfortunate that we have people who work without letter of employment. In fact, the shameful thing is that, to be frank, if you do an audit in Lagos, let me even start from Lagos, which is a metropolis, you'll be shocked to see that there are lawyers who work in law firm and they don't have contract of employment. But every day we go online to shout, we campaign, we condemn government, we say this as lawyers, but some law firms don't issue something as simple as a 1-page or 2-page employment contract. So employment contract is an agreement, whether oral or written, express or implied, whereby one person agrees to employ another as a worker, and that person agrees to serve the employer, typically in exchange for remuneration. We have stated that. So Section 91 of the Labor Act, is very key. It defines what a contract of employment is. So statutory requirement of written particulars. While the Labor Act acknowledges that a contract may be oral or written, Section 7 sub 1 imposes a mandatory obligation on employers not later than 3 months after the beginning of a worker's period of employment for the employer to give the worker a written statement specifying the following particulars. Regardless of the fact that Labor Act says that an employment contract may be written or unwritten, if you look at Section 7 sub 1, it says that within 3 months, not less than 3 months, you must give the person a paper that shows the name of the employer and the undertaking, the name, address, and place of engagement of the worker, the nature of the employment, the date of expiry of the contract, if it's for a fixed term, the appropriate period of notice, the rates of wages, method of calculation, and manner and periodicity of payment, terms relating to hours of work, holidays and holiday pay, and sick pay, and any special condition of contract. Then Section 7.2 imposes a continuing obligation and say where any change is made to these terms, the employer must notify the worker in writing within 1 month of the change. So for non-workers, there is no statutory obligation, that's you and I, to provide a written contract, though it is strongly advised that written contracts be issued for all categories of employees as a matter of prudent practice, because when there is an issue, you have to fall back to the provision of the contract. So we also must have heard about collective bargaining agreement, which is, what protects trade union, once the right to unionize, you come together and discuss with the company or discuss with the establishment as to conditions of employment. In Afribank versus Kule Osisanya, the court held that collective agreements are enforceable where they have been adopted as forming part of the terms of employment. In Union Bank of Nigeria versus EDET, the Court of Appeal held that collective agreements are not generally intended to create legal relations and are essentially extra legal instruments unless incorporated into individual contracts. So the union will always come together. For instance, I give you an issue of redundancy. When you look at most employment contracts, you may not really see details of what happens during redundancy. Redundancy is covered in the level, I think it's section 20 or 21. It tells you what to do. You have to declare redundancy. This is what redundancy is when you have too many people doing the same work and all that. As the word implies, redundancy. So what typically happens is that in an organization where there's a union, the union will come and discuss with the management and say, this is what is going to happen. In case redundancy is declared, senior management staff will get 6 months salary to tell them, okay, sorry, you have to go. Junior workers, something similar to that. So we talk about unfair labor practice in contract terms. So the NICN has used the unfair labor practice jurisdiction under section 254C1 sub F of the Constitution to invalidate certain contractual provisions. And I will give some instances. In Wanguma and Ati Industry Limited, a 2019 case, the court held that a clause permitting indefinite extension of a probationary period is void as an unfair labor practice and deemed the employee confirmed from the moment the initial probation period expired without formal action by the employer. Yes, somebody tells you you are under probation without telling you when it's going to end, or somebody tells you you'll be under 6 months probation. For crying out loud, I actually don't see a reason why someone should have 6 months probation. If you are a diligent employer, within 3 months, you should know whether this person is fit, because you have actually employed that person based on what the prima facie evidence that he has provided that is capable to work. So why keep the person for half a year? Some people, after 6 months, maybe they are not sure or they will forget. The person will continue to work. So if the time between the expiration of the 6 months, let's say after 6 months, 6 months was April ending. The person now works May, June, July, August, September, and something happens. The court would most likely 100%, 99.9% hold that is a deemed constructive confirmation of employment. In IrokoTV.com Limited versus Michael Lubu, the court held that altering the terms of employment to the detriment of the employee after commencement of work was an unfair labor practice. So these decisions reflect the NICN's growing disposition to assess not merely the contractual regularity of employment decision, but their substantive fairness. If we talk about discrimination in employment relationship, the prohibition of discrimination under section 42 of the Constitution and specific legislation operates throughout the entire employment relationship from recruitment to termination. The HIV and AIDS Anti-Discrimination Act 2014 specifically prohibits employers from requiring disclosure of HIV status as a condition of employment or subjecting employees to HIV testing without consent. So you look at AGK Manuka and Microsoft Limited, the landmark NIC case on workplace sexual harassment. The court held that terminating employment of an employee for refusing to succumb to sexual advances constitutes gender discrimination and a violation of the employee's right to dignity under section 34 of the Constitution. It's just that so many people suffer this, but only few are able to take it up for fear of stigma and all that. So the employer was held so section 34 of the Constitution, in that same case, AGK Manuka and Microsoft, the court relied on section 34 of the Constitution, applying the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, General Recommendation number 19, and ILO Convention 111. The employer was held vicariously liable for failing to investigate the harassment. Jamiu Alkolade in his book advises that every employer should maintain a written anti-harassment and anti-discrimination policy, specifying the reporting procedure, prescribed consequences for breach, and a commitment to periodic staff training. And I would add, protection of those who come up to whistleblow or protect the safety. If you work in an environment or if you work in a firm where you are being sexually harassed, and there's no modality to protect the confidentiality of what you report against the big boss, maybe who is a senior advocate, or maybe who is a big man, or maybe who has power, then that means all this things are just for decoration. Then requirement as to pension contribution, yes. The Pension Reform Act of 2014 has imposed a mandatory obligation on employers with 15 or more employees in the private sector and all employers in the public service of the Federation and FCT. If you voluntarily elect, if you're not up to 15 or you just want to do voluntary contribution, it's also allowed. So the contributing pension scheme is that upon employment, each employee must be registered with a pension fund administrator, PFA, of the employee's choice. The PFA opens a retirement savings account in the employee's name, and then monthly contributions are made by both employer and employee in the retirement savings account, and are then invested by the PFA on behalf of the employee. And I can tell you, as someone who has been contributing, I think I started in either 2009 or 2011. It's actually an interesting development in Nigerian law, in that this money is reinvested. They give you online real-time value of what your investment stands. So it behooves on employees, once you meet the threshold, the law says 15, except if you want to now do voluntary contribution, or your employer wants to start even when you're not up to that, they will allow you based on the regulations. So it is interesting because we get old, before you know it, you are old, and you look, yes, even though Naira is being eroded by inflation and all that, but if you have been investing this money over time, no matter how small it is, it's something that an employee can fall back, given that we don't stay young forever. So, of course, the rate of contribution is 10% from the employer, 8% from the employee, and there's a failure to remit on time attracts a penalty of 2% per month on the unremitted amount. So the law was not made in vacuum. If they want to come for you, you may have to cry blood, So Section 445 of the Pension Reform Act provides for group life insurance. This is another interesting development, covering each employee for a minimum of 3 times the employee's annual total emoluments. On a lighter note, when I was head of legal in one conglomerate, one of the workers, laborer, let me even call him, he came one day and inquired to see, Mr. Azzy, this pension, this group life insurance policy, what does it entail? Does it mean that if I fall from the crane now, that the company will pay me, will pay to my family as well? So when I told him what what they would have paid him if you fall from the crane and die, or if anything happens to him, even if you are just traveling, provided you are within the employment range, I think it was either 45 million then. The man told me that, please, that the paper, that I hope none of his family members have heard about it, that he was married to 3 wives. He said that they may put hands together and kill him so that they can have access to the money. So this is a statutory provision that you have to have group life insurance covering your employees. So our trustee and the famous writer who wrote the employment law handbook, Jamiu Alkolade, is going to pay me for all this advert. He knows that non-compliance with pension obligation is one of the most common regulatory infractions by Nigerian employers, and one of the most frequently litigated areas before the NICN. So PENCOM has in recent years significantly intensified enforcement activity, and non-remittance of pension contribution is now treated as a serious regulatory and civil law exposure. So we have the National Housing Fund. Some of these things, when we see it in law, when we see it in the body of our laws, you think it's there for fun. But I can actually confirm that National Housing Fund, I've seen people benefit from it. You know, the 2.5% that is deducted from your basic salary, monthly salary, to the Federal Mortgage Bank. You know, once you contribute, I think for 3 or 6 months, you become qualified. Those days used to be like they can give you up to 15 million, but now I think it has been increased. 50 million naira to get a house. You just meet a mortgage bank, they meet a developer. Maybe if you want to buy a land in Ajangbadi or in Shongotedo or anywhere. Why I'm mentioning all these places that if you want to buy in Ikoyi, of course, you know that 50 million cannot buy. So you make a down payment and they give you loan, and the loan interest is 6%. National Housing Fund is real and it works. So for those who want to take advantage of that. And then we talk about requirement as to freedom to join a trade union. We all were witness to the recent imbroglio between Dangote and and the union. It was heated, to say the least. So there is a constitutional foundation for seeking to unionize. Section 40 guarantees every person the right to assemble freely and associate with others, and in particular to form or belong to any trade union for the protection of their interests. So this is the primary constitutional guarantee of the right to trade union membership in Nigeria. Barrow and Leon observed that the right to freedom of association in the employment context encompasses not just the right to join a union, but the correlative right not to join, a principle that is firmly established in Nigerian law following the Trade Union Amendment Act 2005. So statutory protection, you look at Section 9, sub 6 of the Labour Act, it prohibits any contract of employment from making it a condition that the employee shall or shall not join a trade union, and forbids employers from dismissing or discriminating against an employee on account of trade union activities. We also have to look at Section 12, sub 4 of the Trade Union Amendment Act 2005, which reinforces this by providing that union membership shall be voluntary and that no employee shall be victimized for refusing to join or remain a member of a trade union. This provision together abolished compulsory unionism in Nigeria. But there are, just like we know, for every rule, there are exceptions. So the following categories of workers are excluded from the right to join trade unions: members of the armed forces, members of Nigerian police force, members of the custom and excise service, immigration service officers, prison service officers, they are now called correctional service, employees of the Nigerian Security Printing and Minting Company for obvious reasons, and certain other designated essential service workers or providers. And the jurisprudential basis is clear. I mean, if policemen should go on strike, we may think that policemen are corrupt, that they take bribe and they do X, Y, Z. But if we should test run it and say policemen stay home for 1 week, well, I think we will all beg them to come back to the road because of the essentiality of the nature of their work. So this exclusion is consistent with Article 9 of ILO Convention number 87, which permits national laws to determine the extent to which the guarantees of the convention apply to the armed forces and the police. So these international conventions will typically give you the leeway to localize some aspect of its provision to suit your local realities and peculiarities. So ILO framework, we've mentioned that. Checkoff system, in fact, actually Section 16A of the Trade Union Act actually mandates the employer that the employer shall deduct trade union dues from the wages of union members and remit such deduction to the trade union registered office within a reasonable period. So if you sign up and subscribe to unionism, your employer has the right to deduct their dues because they need money to run the affairs of the union. Then collective bargaining, we have spoken about that. Requirement to employee disciplinary action, the right to discipline and its limits. So essentially, an employer has a right rooted in law, in common law and the contract of employment, to discipline employees for misconduct. As one famous writer observes, He said this right is not absolute and must be exercised with the constraint of the contract, the employer's internal disciplinary codes and rules, the principles of natural justice as guaranteed by Section 36 of the Constitution and applicable statutes. Mr. Kolade, in his book, stated that the practical observation that the most costly employment litigation in Nigeria typically arises not from the substantive merits of a dismissal decision, but from procedural failures in the disciplinary process. And we have to discuss this. Someone had been caught watching porn in the office. And the handbook says that such have been grouped under gross misconduct, because that's not why you are paid. When you get home, you can use 500 gigabytes to watch and enjoy yourself. Now, substantively, the person has done something wrong. But the next thing is that what is the procedure that you have to take to relieve him of his duty? That is where most companies get it wrong. Immediately, oh, he was caught sleeping. He was caught doing this. That's why the handbook says blah, 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 blah. Yes, that's what the handbook says. But why give him a summary dismissal? Why did he shave his head at his back? So the issue of all the alteram patem, as established in the Constitution, as provided in the Constitution, will come. You must inform him of whatever he has done. You must give him the opportunity to defend himself. You must set up a panel, investigative panel that will investigate all the hearing and then let him defend himself. Because even in the Holy Book, God even asked Adam, have you eaten from the forbidden fruit before he was condemned? God knew they had done what he said they shouldn't do, as was reported. I wasn't there. But the point is that that sets the standard that you have to inform people. So if you go to NICN, we have a lot of cases that fall on their head just because the company was right in substantively terminating the employment, but the procedure of relieving the person of employment was faulted. So natural justice in disciplinary proceedings encompasses the twin pillars of natural justice, or the alteram patem, and nemo judex in causa sua. It applies to all employment disciplinary proceedings in both public and private sectors. So when we share the paper, you'll see the details. In the Monike and Unity Bank, the Supreme Court held that the alteram patem rule required that the employee be given an adequate opportunity to be heard before any adverse disciplinary decision is made. Olatunbosun and NISER Council, the court held that the employee must receive adequate notice of the specific allegations with sufficient particulars to enable a proper defense and a genuine opportunity to respond to those allegations before a decision is taken. So the standard disciplinary process should encompass the standard procedure in both public and private sector organizations, should involve, number one, a formal written query setting out the specific allegation in sufficient detail, a reasonable period for the employee to submit a written defense or rebuttal, and then an impartial investigation by a properly consulted panel. If you know that this man has been criticizing Mr. Obi every day, and he was even the one that reported him, you cannot make him the head of the disciplinary panel. That will offend the rule of natural justice. So a disciplinary hearing at which the employee may appear, present their case, and challenge the evidence against them. That's number two requirement. Then a reasoned decision communicated to the employee, an internal appeal mechanism where, must be provided by the employer's policies or the applicable statute. We are handling a case where someone went through disciplinary hearing, and after a verdict was given, you just said, okay, you have been terminated. The details of the proceeding was not sent to him. They just left it that way. It was only when we went to court that they said, oh, he wasn't entitled to a copy. No, he was, actually. You have to be informed that this is the basis for us to terminate you. So we talk about the employee handbook as a binding legal document, and I think over time the NICN has consistently held that an employer's employee handbook or disciplinary policy constitutes a binding legal document. There are cases to back up that. In one of the cases, the court confirmed that failure to follow the procedure set out in the handbook is a denial of fair hearing and renders any resulting dismissal wrongful, regardless of the substantive merits of the misconduct in the allegation. There are handbooks that provide a multi-layered disciplinary approach. And what that means is that if Mr. Aze had harassed somebody, shouted at somebody in the office, or fought with someone in the office, and the handbook says, first of all, give Mr. Aze a query. If he doesn't answer the query well, report him to the supervisor. If he does it the second time, deduct his salary, or, it is graded, multi-layered, until you get to the final stage where you now terminate the person. What some companies do is that maybe they don't like your face. Once they set you up, maybe you shouted at someone at the office, they just yank you off. So, excuse me, what some of these cases are saying is that even if in substance, Mr. X is liable to the allegation, you must follow the procedure. So it's an issue of, this is the substance, this is the rule in handbook, then this is the process of arriving or enforcing that substantive provision. However, there's a provision for summary dismissal, regardless of all that we have discussed in the past. So an employer may dismiss an employee without notice where the employee has engaged in gross misconduct, conduct that strikes at the root of the contract and renders it continuous impossible. Examples include theft, fraud, serious dishonesty, gross insubordination, and willful destruction of the employer's property. Even in cases of gross misconduct, however, the requirement of fair hearing cannot be dispensed with. And that was what the court said in University of Calabar versus Essien 1996, a 1996 case. The court confirmed that summary dismissal is only lawful where the allegation was disclosed to the employee, a fair hearing was given, the disciplinary panel followed laid down procedure, and the employee was found culpable. This was even before NICN. If you go to NICN portal, you'll see millions of cases on this issue. So unfair labor practice in disciplinary proceeding, the NICN has used its unfair labor practice jurisdiction to police the manner in which disciplinary processes are conducted. In one of the cases, the court held that failure to follow the company's detailed disciplinary procedure and imposition of arbitrary sanction outside company policy constituted unfair labor practice and other substantial damages. In other words, you cannot go outside the ambit of your handbook. There's a reason for the handbook. If the handbook says X, Y, Z, you cannot say, oh, no, we need to do X, Y, Z. No, you must follow the handbook. So for statutory employees whose employment has statutory flavor, civil servant, police officers, armed forces personnel, the applicable statutes and regulations prescribe specific disciplinary procedure that must be strictly followed. Any measures or dismissal not in compliance with those procedures is null and void. See CBN and IGWILO. And we talk about modes of termination. We have termination by notice, termination by payment in lieu of notice, summary dismissal for gross misconduct, redundancy. We're going to talk about redundancy, expiry of a fixed term contract, constructive dismissal, debt, and mutual agreement. Two areas I want to highlight: redundancy and expiration of a fixed term contract. What happens in practice is that some human resource people, apologies to any human resource person who has joined us, some human resource person mistake redundancy for termination for cause. But when you look at the Labor Act Section 20, you see that redundancy is simply saying, for lack of a better word, you are no longer useful to us. Not because of the competence, no, but because of structural or organizational issues. 6 lawyers are in this bank's legal department. Those days, we used to have a lot of customers, a lot of searches that allows this one, that one, debenture, XYZ. But now, some of these things have been mechanized. Auntie Flora, please, we need to relieve you of your duty. You are the last to be hired, because the principle is last in, first out. When a company has declared redundancy, for instance, it must be declared. It is not something you target against one person. The MD or whoever must come, maybe call a meeting and say, oh, because of XYZ, because of technology, because of our dwindling economy, we can no longer maintain payroll, or we have a lot of people doing the same job. You now look at the collective bargaining agreement. What does it provide? You now give them soft landing. Can you send them to your office in Ogbomosho if there is opening there? Can you help them get somebody who can coach them on what to do after they have been yanked off? These are things you need to do. So you don't just wake up. That is why in Elizabeth Oloyede and NTA, I think it was Milord Kanyib that decided that case. A lawyer was, they call it redundancy. One person redundancy. I hope I can still be heard. A lawyer was yanked off from a company and they said it was redundancy. Milord went to town and said no, because after a few months, they hired another lawyer. So it was more like you are doing your work well, maybe because I don't like your face, there's no reason, and I call it redundancy. So there's a growing trend among companies, human resource people. You have looked at the person's file, it's clean, no gross misconduct, he's doing his work well, but for some reasons, you want him or her out. So what you do is that you come under that general omnibus clause, services no longer required. What does that mean? Services no longer required for what? Because of his color, or because of the way he comes to work, or because of what? So you must give reason. So we have to draw a distinction between redundancy and outright dismissal or termination. Because when somebody's employment is terminated, except when you are terminating by giving 1 month notice in lieu, you have to give a reason why you are terminating now. Those days it used to be that, oh, no reason, so 1 month notice or salary in leave. But now, the NICN, by applying the national best practice, say you have to give reasons. Forget about the controversy in Court of Appeal and Supreme Court. We're still going to get there. But if you want to go strictly by the third alteration and the relevant provision in 254C and the rest, you have to give reason. Relying on Article ILO International Convention 158, which the Constitution itself, the ground norm, has given the NICN the power to adopt. You can't just wake up and say redundancy. Redundancy must be specifically proven in your letter you refer to it. If it's not redundancy, you look for any other reason to dismiss that person. Then we'll talk about fixed term contract. I'll give you an example. A lady was hired by a bank, one of these red banks, for a fixed term contract of 1 year. What it means is that the contract of employment says you are going to work for us for 1 year. Maybe subject to renewal, but it's at our own discretion. Your salary is 10,000, for instance. I'm just giving an example. This lady started work after 3 months. Because when you start work, they will take your blood for tests and everything. So when the blood result came back, the lab told them that the lady was pregnant. They sacked her. They didn't give her a reason for sacking her, but she heard it from the backyard. They just woke up one day and said, service is no longer required. After 3 weeks, not even 3 months, 3 weeks, if I remember correctly, but I handled the case. So we are sacking you. She came to us. We saw the contract. Because I've forgotten the case. When you give somebody a fixed term contract and you terminate before that term has expired, the law is that you will pay that person the value of that 1 year, if it's 1 year, if it's 6 months. And that was what we negotiated. At the end of the day, we settled the case with about 90% of what she would have earned in 1 year. But that's by the way. So when you look at Section 11 sub 1 of the Labour Act, it prescribes the following minimum notice periods, less than 3 months, 1 year, 3 months to 2 years, 1 week, 2 years to 5 years, and the rest of it, 5 years and above 1 month. So these are statutory minimums. Parties may agree to longer notice periods in the contract, but may not contract below the statutory benchmark. So for non-workers, remember the distinction between workers and non-workers in Labour Act. It's a controversial issue. The applicable notice period is determined entirely by the contract of employment. Largely, we have in Nigeria 2 weeks and 1 month. 1 month is most common. So payment in lieu of notice is statutorily recognized. Section 16, 11 sub 6 and 9 of the Labour Act permit either party to terminate immediately by paying the salary that would have been earned during the notice period. Either party may elect this option. So redundancy, I've spoken about that. The Labour Act defines redundancy as an involuntary and permanent loss of employment caused by an excess manpower. Labour Act is somehow restrictive. The existential definition now will encompass excess manpower, 5 lawyers doing the work of 1 person, that they use 6 hours in the day to browse through Linda Ikeji or TikTok or watch the latest Korean movie. The company says, why are we paying you every month? You have become redundant, because the English word redundant means we are not being utilized to your best capacity, so to speak. So when the employment is terminated on grounds of redundancy, the employer must notify the worker and the recognized trade union of the reason and extent of the anticipated redundancy, and must apply the principle of last in, first out, LIFO, in selecting employees to be affected and negotiate and pay redundancy benefit. LIFO means last in, first out. The last person to be hired after every other thing has been considered, competence and everything, the last person to be hired should be the first to be yanked off, for lack of a better word. So constructive dismissal, we're almost done, so that I don't overshoot the time that has been allocated to me. Constructive dismissal arises where the employer's conduct fundamentally breaches the contract of employment through harassment, arbitrary reduction of salary, deliberate failure to honor a commitment to promote, or any other fundamental breach, making the employee's continued service impossible, and the employee resigns in response. 2 more minutes, yes, I am almost done. An employer can actually terminate or dismiss an employee without specifically doing so. And that is what we have stated. When you make condition terrible for that person, the person comes to work and maybe your desk has been taken by another person. I have a case where, in fact, it happened to the human resource person. He fell out with the MD. He came to work and he saw that the MD was sitting in his desk. The MD sat on his desk throughout the day. The following day, he came and saw the MD on his desk. So if you are in his shoes, what will you do? You won't go and create a desk for yourself. You just deem yourself to have been constructively, dismissed. I think it was Bimbo Atalola that notes that this doctrine was introduced to Nigerian jurisprudence by the NICN, this doctrine of constructive dismissal, and it represents a significant departure from the traditional common law position. The NICN confirmed in Lucy Abalong versus Voluntary Service Overseas International that proven constructive dismissal entitles the claimant to general damages. So notice requirements, you have to give notice in writing, and the notice period runs from the date of service. The minimum period prescribed by Section 11 of the Labour Act apply as set out in the outline above, what we have stated earlier. So for non-workers, the notice period is entirely contractual. So it's also important for us to understand that when somebody puts in a letter of resignation, and effective the time your letter of resignation has gone in, you are technically no longer an employee of that place. Like, it takes effect. Because I've had people come to me to say, I put in my resignation and my employer rejected it. What is the implication of that? So reasons for termination, we have spoken extensively about that, on the ground that the traditional common law position in Nigeria that an employer may terminate a contract of employment without providing reasons, provided the contractual terms are followed, has been substantially eroded by the NICN. Because what the common law says is that you can hire and fire, but just follow what you have in the contract. Maybe salary in lieu or 1 month notice. But In cases like Ebere Onyekachi, Aloysius, and Diamond Bank in 2015, the court held that it is contrary to international level standards and international best practice for an employer to terminate employment without a valid reason connected with the employee's capacity, conduct, or the operational requirements of the undertaking. And that dovetails with Article 4 of ILO Convention number 158, which Nigeria has not domesticated, but the progressive, for lack of a better word, judges and the NICN have been applying following the mandate given to them by the third alteration. We also have Mr. Oscar Obasi and First Bank, Bello Ibrahim and First Bank, and the rest. Some writers, however, caution that this development remains the position of the NICN alone. The Court of Appeal confirmed in Keystone Bank and Afolabi that the common law right of an employer to terminate a contract of employment without assigning reason remains valid, provided the terms of the contract are complied with. The position of the higher courts on this question has not been definitively resolved. And in wrapping up, that takes us to what the Supreme Court has done in the recent time. I want us to, I didn't put this case in my original write. I want us to note the case of Skybank PLC versus Adegun. Skybank versus Adegun, Adegun. Supreme Court 406/2018. The 2024 case. And then Dangote Cement PLC versus AGA and others. AGA is AGER. 2024 LPELR 61800 Supreme Court. In the first case decided by the Supreme Court beautifully adopted international best practice, on equitable grounds. Oh, you must give reasons, you must follow the process, do this one, give reasons, blah, 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 international best practice. Then, within the same year, in Dangote Cement and AGA, they said no. They restated what the Court of Appeals stated in Keystone Bank and Afolabi, that the common law right of an employer to terminate a contract of employment without assigning reasons remains valid, provided the terms of the contract are complied with. So what does that leave us to? I just want to read out what a view expressed by someone on this case. Yes, he said, there is an urgent need for doctrinal clarity. The Supreme Court must seize the next opportunity to reconcile these diverging lines of authority and provide clear, unambiguous guidance to lower courts and stakeholders in the employment space. The dignity of work and the evolving nature of employment relations in a globalized world demand no less. Until such clarity emerges, legal practitioners will be well advised to prepare for a two-pronged strategy. Argue for Adegun when seeking justice for wrongfully dismissed employees, but be prepared to confront the shadow of Dangote when representing employers. Ultimately, these decisions leave the practical application of international best practices in Nigeria employment law somewhat unsettled. Whether Adegun heralds a permanent shift towards integrating global standards of fairness, or whether Dangote will continue to anchor employer prerogatives remains to be seen. What is clear, however, is that all stakeholders must remain attuned to these evolving judicial trends as the balance between contractual freedom and international labor practice unfolds. So that is the essence of what we have been discussing, that we need to continually follow these trends and hope in the hope that in the nearest future, some of these issues, will be finally laid to rest by the Supreme Court. We have some other points we need to make, but I think we need to wrap up. Since we have promised to share the paper, you can digest in details. We have barely scratched the surface of issues surrounding, employment law and regulation in Nigeria. But the idea is to provide a foundational discussion, as elementary as it is, for the interest of stakeholders, lawyers, non-lawyers, who are interested in this emerging jurisprudence. Employment and labor law has always been there, but this emerging jurisprudence and the dynamics and imbroglio, conundrum between international best practice and what's obtained under common law, is something that every keen observer is keen to see how it unfolds. So thank you for tolerating my long speech. I hope I have not confused you, but I've convinced you on certain issues. Thank you very much.
Oh, wow. Thank you, Mr. Nonso. That was a very in-depth analysis that you have done to the labor and employment law jurisprudence in Nigeria. We had a lot to unpack, and in a couple of minutes, you have been able to spread your tentacles around the necessary and important areas for consideration. So we'll go to questions and answers session. Couple of questions, but I have one from the chat box. I'm going to read that. The reader says that we all know that an employee is entitled to full salary upon termination, irrespective of the day of the month the termination took effect. The question then becomes, would the National Industrial Court treat payment in lieu of notice as a full calendar month salary, irrespective of the day of the month the termination took effect, or a rolling 30-day period from date the notice took effect? Mr. Nonso, I don't know if you got that question right.
Yeah, first of all, there are a lot of cases. I don't have one at hand now. I think Obuanya, in one of his seminal decisions, stated that you cannot treat salary as because calendar months, as we have it, the Gregorian calendar months, some months are 28, some are 29, some are 30, 31. So if your salary is 100 naira, it remains 100 naira, whether we have 10 days public holiday of that month. Whether the person called in sick is salary, because it's salary as against wage. If it's someone who gets paid per hour or who gets paid daily or weekly, that is when you can begin to do the mathematics to say, oh, you worked today and you didn't work today. Otherwise, the salary in lieu of payment is salary as set out in the contract or by practice. So there are case laws to back. It's correct. You
Mr. Alonso, are you still there with us? Hello, can you hear me?
Sorry, hello, can you hear me, please? I'm sorry for that breaking transmission.
Okay, yes, we can.
Yes. I'm so sorry about that, yes. Okay, so you can't say salary is salary, regardless of, it is not mathematical. So if you are required to give 1 month salary in lieu, it has to be your salary as you receive it. I don't know whether that has answered the question, because the question was a bit complicated, yes.
Okay, all right, thank you, it does. So you had on the call mentioned something about the employer cannot terminate employment without adhering to the terms of employment and what have you. So I have a question, and the question is, what is the fate of employees who do not have letters of employment and conditions of employment given to them at the time of employment? What remedies do they have in terms of termination or contractual benefit in relation to employment? Thank you.
Yes, so depending on the category of work, if the person is a worker are defined in Labour Act, you resort to Labour Act. The Labour Act has stated clearly, you should give 2 days for this, 1 day for this, blah, 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 blah. But if it's the other category of employee, where you are supposed to have a contract, so to speak, and remember that Labour Act mandates you after 3 months to give. And if you don't give, you can fall back to the Labour Act. So there are precedents there as to what is a reasonable notice. So if someone is a lawyer, and he doesn't have a contract, it will be deemed, his paid salary every month, it will be deemed that if he wants to resign, he should give 1 month notice at least, or what the court has in certain cases defined as reasonable notice. So there is always a fallback. You fall back if in the absence of a contract, you can look at the law. In the absence of the statute, and if it's not applicable, you look at the case law. That's what the court has interpreted to be a reasonable. On all spheres of employment, there are decisions where the court has clarified that this is what should ordinarily obtain, in such cases.
Okay. Thank you, Mr. Nonso, for the effective answer. Just to note that the slides will be circulated to participants after this webinar. And on that note, I want to appreciate Elan. Okay, so we have a lot of accolades for you, Mr. Nonso. They're on the chat box, and because of time will fail me to read them. I was about thanking Elan for the opportunity to allow members of the public to get granular understanding of the current position of the law on employment and labor in Nigeria. It's very intricate and necessary positions that people need to know, understand their rights, obligations, and benefits under the various labor laws, including international labor treaties. So I'm going to be handing over to our host representative, Madam Alicia Adefarasingh, to give us a closing remark whilst thanking Mr. Nonso for taking out time to lecture us. Indeed, it was a very great and elaborate lecture. Thank you once again. Over to you, Alicia.
Thank you so very much, Mr. Nonso. That was absolutely brilliant. That was a crash course in employment law, employment and labor law. We do really appreciate it. And I'm sure everyone on this call has, I can see the comments coming in. I'm sure it was very beneficial for everyone on this call. Thank you everyone for your time, participation today. And a special thank you to our facilitator and moderator for sharing, such valuable insight